Bouvier's Law Dictionary, 1897. Definition: common law. Common law. That system of law or form of the science of jurisprudence which has prevailed in England and in the United States of America, in contradistinction to other great systems such as the Roman or civil law. Those principles, usages, and rules of action applicable to the government and security of persons and of property, which do not rest for their authority upon any express and positive declaration of the will of the legislature. The body of rules and remedies administered by courts of law, technically so called, in contradistinction to those of equity and to the canon law. The law of any country, to denote that which is common to the whole country, in contradistinction to laws and customs of local application. The most prominent characteristic which marks this contrast, and perhaps the source of the distinction, lies in the fact that under the common law, neither the stiff rule of a long antiquity on the one hand, nor on the other, the sudden changes of a present arbitrary power are allowed ascendancy, but under the sanction of a constitutional government, each of these is set off against the other, so that the will of the people, as it is gathered both from long established custom and from the expression of the legislative power, gradually forms a system, just because it is the deliberate will of a free people, stable because it is the growth of centuries, progressive because it is amenable to the constant revision of the people. A full idea of the genius of the common law cannot be gathered without a survey of the philosophy of English and American history. Some of the elements will, however, appear in considering the various narrower senses in which the phrase common law is used. Perhaps the most important of these narrower senses is that which it has when used in contradistinction to statute law, to designate unwritten as distinguished from written law. It is that law which derives its force and authority from the universal consent and immemorial practice of the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law. When it is spoken of as the lex non scripta, it is meant that it is not law written by authority of law. The statutes are the expression of law in a written form, which form is essential to the statute. The decision of a court which establishes or declares a rule of law may be reduced to writing and published in the reports. But this report is not the law. It is but evidence of the law. It is but a written account of one application of a legal principle, which principle, in the theory of the common law, is still unwritten. However artificial this distinction may appear, it is nevertheless of the utmost importance and bears continually the most wholesome results. It is only by the legislative power that law can be bound by phraseology and by forms of expression. The common law eludes such bondage. Its principles are not limited nor hampered by the mere forms in which they may have expressed, and the reported adjudications declaring such principles are but the instances in which they have been applied. The principles themselves are still unwritten and ready, with all the adaptability of truth, to meet every new and unexpected case. Hence it is said that the rules of the common law are flexible. It naturally results from the inflexible form of the statute or written law, which has no self-contained power of adaptation to cases not foreseen by legislators, that every statute of importance becomes, in course of time, supplemented, explained, enlarged, or limited by a series of adjudications upon it, so that at last it may appear to be merely the foundation of a larger superstructure of unwritten law. It naturally follows, too, from the less definite and precise forms in which the doctrine of the unwritten law stands, and from the proper hesitation of courts to modify recognized doctrines in new exigencies, that the legislative power frequently intervenes to declare, to qualify, or to abrogate the doctrines of the common law. Thus the written and the unwritten law, the statutes of the present and the traditions of the past, interlace and react upon each other. Historical evidence supports the view which these facts suggest, that many of the doctrines of the common law are but the common law form of antique statutes, long since overgrown and embedded in judicial decisions. While this process is doubtless continually going on in some degree, the contrary process is also continually going on, and to a very considerable extent, particularly in the United States, the doctrines of the common law are being reduced to the statutory form, with much modifications, of course, as the legislature will choose to make. This subject is more fully considered under the title Code, which see. In a still narrower sense, the expression common law is used to distinguish the body of rules and of remedies administered by courts of law, technically so called, in contradistinction to those of equity administered by courts of chancery, and to the canon law administered by the ecclesiastical courts. In England, the phrase is more commonly used at the present day in the second of the three senses above mentioned. In this country, the common law of England has been adopted as the basis of our jurisprudence in all the states except Louisiana. Many of the most valued principles of the common law have been embodied in the Constitution of the United States and the constitutions of the several states. And in many of the states, the common law and the statutes of England in force in the colony at the time of our independence are by the state constitution declared to be the law of the state until repealed. There is an express constitutional adoption of it in Delaware, New York, Michigan, Wisconsin, and West Virginia, and an implied adoption of it in the constitutions of Kentucky and West Virginia. It has been adopted by statute in Arizona, Arkansas, California, Colorado, Florida, Idaho, Illinois, Indiana, Kansas, Missouri, Montana, Nebraska, Nevada, New Mexico, North Carolina, Pennsylvania. South Carolina, Texas, Vermont, Virginia, Washington, and Wyoming. It was extended to Alabama by the Ordinance of 1787 and the recognition of the latter in the state constitution. It is recognized by judicial decision without any statute in Iowa, where the rules adopted by several states in this respect are stated. Hence, where a question in the courts of one state turns upon the laws of a sister state, if no proof of such laws is offered, it is in general presumed that the common law as it existed at the time of the separation of this country from England prevails in such state. In Pennsylvania, in cases where that state has changed from the common law, the presumption being that the law of the sister state has made the same change if there is no proof to the contrary. The term common law as thus used may be deemed to include the doctrine of equity, but the term is also used in the amendments to the Constitution of the United States, Article 7, in contradistinction to equity, in the provision that, quote, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, end quote. The common law here mentioned is the common law of England and not of any particular state. The term is used in contradistinction to equity, admiralty, and maritime law. The common law of England is not in all respects to be taken as that of the United States or of the several states. Its general principles are adopted only so far as they are applicable to our situation, and the principles upon which courts discriminate between what is to be taken and what is to be left have been much the same, whether the common law was adopted by constitution, statute, or decision. While no hard and fast rule can be laid down, which will at once differentiate every case, a very discriminating effort was made by Chancellor Bates in Clausen versus Primrose to formulate the result of the decisions and ascertain the criterion which they had in most instances applied to the subject. In this discussion, which was characterized by Professor Washburn as the best he had ever read, the conclusion reached is thus stated. Quote, it cannot be overlooked that, notwithstanding the broad language of the Constitution, in parentheses, the common law of England, as well as so much of the statute law as has been heretofore adopted in practice, such parts only accepted as are repugnant to the rights and privileges contained in this Constitution and the Declaration of Rights. There were many parts of the common law of England as it stood prior to 1776, which never have in fact been regarded by our courts as in force in this country, yet it is to be observed that the courts have not herein acted arbitrarily in adopting some parts of the common law and rejecting other parts, according to their views of the policy of particular rules, or doctrine. On the contrary, those parts of the common law of England which have not been here practically administered by the courts will be found on examination to reduce themselves to two classes, resting upon grounds which render them proper to be treated as implied exceptions to the constitutional provision, in addition to the expressed exception of such parts of the common law as were repugnant to the rights and privileges contained in the Constitution. One of these classes of exceptions may be briefly disposed of. It embraces those parts of the rules and practice of the common law which had become superseded by long-settled usages of trade or business, or habits of dealing among our people, such as could not be unsettled or disturbed without serious inconvenience or injury.